Well, the laws in which I tend to go ahead and explain to individuals out there who have loved ones who are incarcerated in the state of Tennessee, and also to the incarcerated themselves, I would like to bring to the attention to them and whom are challenging their cases pro se, the laws of the pro se litigants' rights, because in Tennessee, the Court of Criminal Appeals and the state courts do not want to recognize such laws under liberal construction. So let me explain to you what liberal construction is. Liberal construction is where the pro se litigant who files without an attorney is held to less stringent standards than bar-registered attorneys, meaning if they file a petition and it's failed in any kind of fault whatsoever, the court is mandated by law under liberal construction under the case of Haynes v. Kerner, 404 U.S. 519 of 1972, to actually sit there and let the pro se litigant know how it was failed and give them a chance to correct such document to be able to proceed. But here in Tennessee, they don't allow such a thing. Just like if you try to submit evidence to equal protection laws, right, under 42 U.S.C. 1981, they try to deny you. These things have been happening for a while. So when it comes to such pro se litigants' rights, when you file your petition for Haynes v. Kerner under liberal construction, also quote that you have a right to repair your pleadings for your loved one, because under Platsky, P-L-A-T-S-K-Y, v. CIA, 953 F2D 25, it clearly states that courts are to review pro se litigants' cases and petitions with less stringent standards for bar-registered attorneys, regardless of deficiencies in their pleadings, therefore showing an abuse of discretion per the coroner and Platsky Supra. And due to Anastroff v. United States, all pro se litigants have a constitutional right to have their claims adjudicated according to the rule of precedent. So if the courts ain't allowing them to rule of precedent, they need to appeal such decision to the Supreme Court and go into a jurisdictional and constitutional question. Because if you don't challenge a jurisdictional constitutional question under Rule 11 of the Supreme Court has a right to deny to even hear the petition. In Tennessee, both the Court of Criminal Appeals and the Supreme Court are in the same building. So, of course, they're familiar with one another, the judges. But off of that, now some of you know how to argue your stuff and to apply your constitutional rights to be liberally constructed. If they don't fail to comply with it, they lack the subject matter jurisdiction to hear anything and therefore reverses the proceedings. Now, when it gets to something that's kind of really, really important in the state of Tennessee, in Article 2, Section 20 of the Tennessee Constitution, it clearly states that all laws are to be enacted by the General Assembly. That's exactly what it says. And that pursuant to such cases, and we're talking about old cases ever since the dawn of time, as such is to be on the face of the petition. Hence, so when you're doing an indictment, you'll notice in Tennessee that it says that it has to state on the indictment against the dignity and the people of the state of Tennessee for it to be a sufficient indictment. The same is when it comes to Article 2, Section 20, where it says being enacted upon the law itself, basically. So if you look at any statute in the state of Tennessee on a criminal statute, nowhere will you see where it says be it enacted by the General Assembly, showing the law is incomplete and therefore lacking the main principle in which brings a person to court on trial and sentence, and which is called the enacting clause. So if it lacks the enacting clause, it is considered to be void, and it's considered also to be a fatal defect. Let's take, for instance, indictments and true bills and stuff like that. So if you look at your true bill, if you're an inmate or if your loved one and you have a person incarcerated, and you look at their true bill and you see that there's a witness that went before the grand jury, or the real accuser is what they call them, and the signature's the same, then you know that if it's a hand-wrote signature, the state of Tennessee has forged such signature, and it's probably likely that the indictment is a fatal defect before it. But the main thing in which needs to happen is people need to write the district attorney and ask them for a copy of either the grand jury proceeding video with audio, the transcripts, or the minutes themselves. And when the DAs write back stating there's no such thing as proceedings because they're held in secrecy and they don't have them because they've done that plenty of times, and that they don't exist, then clearly under their own statute of TCA 4013-109, the entry of the minutes of felony indictments, all indictments for public offenses of a grade of a felony returned into the court by the grand jury with endorsement, true bill shall be entered by the court, showing that they actually took place. But under the sufficiency, under the Henry v. State, case of 23 TENN.270, 1843 Tennessee.Lexus, 78, 1842, it clearly says that the failure of the record to show that the grand jury returned into open court with a bill of indictment for a felony endorsed a true bill is a fatal defect. Now, if you have a fatal defect, then we go to the main principles of anyone ever challenging their conviction. We all know that if you know anything about the law, you challenge the indictments first and make sure they're accurate. If they're not accurate and they have a fatal defect, the court was in want of subject matter jurisdiction, meaning that everything after such is considered to be null and void. So therefore, the sentence is null and void. And if you prove in a local state habeas corpus court, wherever you're at, so say, for instance, you're in Tennessee, you're at like or West Tennessee somewhere, you're going to go to the local, that county's circuit court to file a habeas corpus. You're not going to file it in a federal court, not right now. And the state habeas corpus where you're locally incarcerated at is where you file it at, and you're going to file such as a fatal defect. And that because the court and the clerk and everybody have to prove that the grand jury proceedings actually took place through the minutes. Now, even though they're to be held in secrecy, there is an exception to the secrecy rule in Tennessee, and it's under Rule 6K2 of the Tennessee Rules of Criminal Procedure. If you prove perjury during the trial in any way, shape, form, or fashion that might lead to the witness committing perjury, and it's a substantial cause before the grand jury, you have a right to acquire the record. Now, once you ask for it, and they tell you once again, like I said earlier, they don't have it, they clearly violate the law and shows a fatal defect so great that the indictments are void and they lack the subject matter jurisdiction to prosecute individuals. Now, I don't know if this happens in any other state of Tennessee, but I know it happens in Tennessee. And these things should not be done. If the enacting clause of the Constitution of the state of Tennessee clearly states that such be enacted by the General Assembly to be actually, when you go into detail of it, it says to be upon the face of the record in the law itself, then nowhere in any kind of nexus, lexus, or anything in the prisons or anywhere the evidence in which you print out say anything about the General Assembly to be enacted, showing that technically none of the laws in Tennessee are actually full laws, showing they lack the main enacting clause to be able to bring someone to the trial. So that could be argued if you know how to argue it in a certain way. Of course, I would advise you to go to somebody who knows the law and the legal law library if you're an inmate listening to this. If not, you can ask other paralegals or law officials out there who had free time to talk to you, like lawyers or something, if you're a family member. They're really going to tell you that everything I'm telling you is pretty much the truth, that if the state of Tennessee lacks subject matter jurisdiction, your loved one is in prison wrongfully, and if you prove such, and it's a fatal defect and the court agrees, that you ask for actually a dismissal and vacate the sentence with prejudice, and therefore you also, when you do such, ask for an immediate expungement and an immediate release from the warden of the facility in which you're at. Now, like I said, I don't know if these things are happening in any other state of Tennessee, but they may be. You never know. But as it comes to the state of Tennessee, like recently, we had the DOJ come down to Memphis, Tennessee, and investigate the wrongful police practices in Memphis. And clearly, recently on the news, they said that they're really not going to pay attention to what they're doing. They're doing their own thing, and they're not going to listen to the DOJ in so many words in certain areas. But, and of course, they're saying, oh, we're cleaning up this, and our crime rate's down this and that and this and that. Well, if the DOJ had to come down and put it up in the media for Memphis to get themselves straight, my question is why didn't the DOJ go to Nashville or East Tennessee? For instance, like the case I've been following and researching, Clarence Hayes' case, in his case, like Article 2, Section 17 of the Tennessee Constitution states, there cannot be two laws inside of one law statute, but yet they try to do it. For instance, in his case, they tried to put on his indictments that he committed felony first-degree murder. But yet when they go before a jury, they say criminal responsibility of felony first-degree. Those are two different laws, two different statutes, but yet they tried to charge him for one, showing that, once again, that conviction is void because it was a fatal defect. Now, if it's a fatal defect, once again, we have a problem with the subject matter jurisdiction, and the court lacked the right to sentence him and imprison him, just like the state and judges, when they get the indictments when it's returned, if it ever does return, because in Tennessee, if they don't have any evidence that the indictments went before a grand jury, or a grand jury introduced any indictments, isn't it illegal and void? They got to have some kind of proof. If they don't have it, that's the main way to challenge convictions here in this state. You file it in your local state good habeas corpus court that you're close to. Also, in the state of Tennessee, there are several statutes in which they've come out with that tend to want to breach the defendant's rights to obtain evidence in their favor, just like present previous testimony of individuals who committed perjury before court. So there was this one case in which I read about where this guy actually was testifying against an individual, and this other female got on the stand and started testifying. And the female, in the previous hearing, decided to say something totally different. So when the guy that was accused wanted to sit there and challenge such under the impeachment clauses, the judge denied him. So if a judge denies to challenge impeachment in cases and they deny the right to obtain evidence in the favor, what's going on in Tennessee, really? I mean, seriously, how come all these people are getting locked up without evidence of the fact committed? You know, in the Tennessee, under the area where it talks about in the Constitution, I want to say maybe Article 7, it says that no person shall be held, Article 1, Section 7, my bad, no person shall be held for a crime, and also that the prudent poisonous tree doctrine comes into play as well when it comes to such, because it says that without evidence of the fact committed, such incarceration ought not be granted. Now, if you go to the Library of Archives in Tennessee about the word ought not be granted, that's quoted in the Tennessee Constitution, if you look at the word archives and have them mail it to you, the word ought back in 1776 era in the dictionary clearly said duty. So the court had a duty not to grant such, and yet they're doing it all the time. So is Tennessee committing treason against its citizens? Are they committing terrorism for their own political gain or profit? So when they go and they incarcerate someone, they use and request a bond from the IRS. That bond is called a certain type of bond in which you can always claim it back yourself and cancel the debt out, and then you can challenge your convictions as they don't have any standings to proceed. But that's some other time. We'll talk about that if you want to. But when it comes to the people's rights here, I just wanted to bring to the attention of them that they need to always argue upon the face of the petition that they request the court to review their petition as a pro se litigant under the statutes and procedures of precedent in Haynes v. Turner and Platsky v. CIA, and also in Anostroff v. United States, which the case number for Anostroff is 223F3D848 of the 8th Circuit, showing that all litigants have the constitutional right to have their claims adjudicated according to the rule of precedent. So, with all that being said, I hope some of these things have helped people out. I really strongly advise someone like in the state of Tennessee, maybe the Tennessee Innocent Project or somebody like that, to look into Clarence Hayes' case. The man done 20 years in prison wrongfully after all the evidence in which I've seen, even upon the screen of LexisNexis and stuff. And one wonders why such things took place, but only he knows. Maybe you might want to have him reach back out to you or something and talk more about the situation. But all I know right now is this court lacks subject matter jurisdiction in his case. The court lacked warrant of jurisdiction in this case, which is kind of similar. It's just the court lacking it, not the state. And they did it out of pretenses, from my understanding, just because of a female wanting to get back at him and lying on him. So what is really wrong with Tennessee? Nowhere will you ever find a serious charge for perjury. Why is it people are lying on individuals and getting a slap on the wrist and making these individuals do 20 years of their life? You know, under the word domestic terrorism, under the statute of the Terrorism Prevention Act, it states that when one commits an act of terrorism, whether it be domestic or foreign, we're not talking about terrorism of blowing stuff up. Terrorism, under the word dictionary of terrorize, says to coerce by threat or violence. That actually includes lying as well. So if you're terrorizing someone by throwing them in prison, which is an act of violence because you wanted to lie on them, you know, in there it states that that defendant has a right to charge that individual who lied with first-degree murder. So why ain't they upholding their laws here in the state? Why do they want to disregard such? Why do they not want to follow their rules of precedent? One might have to ask themselves that question and wonder why their loved one's sitting in prison illegally in violation of the enacting clauses of the statute, since nowhere on the face of every state there is an enacting clause on any of the laws that are presented for the inmates or for anybody in the books and stuff. The only enacting clause they have is on one document, and that's not good enough on the face of the petition. Not pursuant to old statutes and laws. nor the due process of the Constitution. Also, when the judges don't want to allow you to give evidence in support of your claim in violation of the right to give evidence under 42 U.S.C. 1981 and the 14th Amendment of the United States Constitution, such you can file a judicial complaint on in the Board of Judicial Misconduct and make sure you include in there that they violated their oath of office and therefore removes judicial immunity and therefore sets into play a 42 U.S.C. 1983 class action because they went against Canon 2A. They showed partiality towards the state and not towards the defendant in violating liberal construction. These things need to be included if you're listening in any kind of petitions in which you so want to file or help your loved one get out of prison if you know they've been wrongfully done or if they've been over-sentenced. Other than that, I think I pretty much covered everything which I'd like to speak about today. Just always remember, first of all, when you're challenging your conviction, challenge the indictments. If you can see something that's wrong in the indictments, pull up the statute on grand jury proceedings, your rules of court and everything. When you show a fatal defect, file your habeas corpus. If you prove subject matter jurisdiction lacking, they got to dismiss your case and vacate it. They can't hold you. Holding you would be a breach of treason and domestic terrorism laws of the state.